Hello, everyone. Sufit here. I'm here today with Charles B. Ticker, estate mediator, and we're here to discuss an interesting topic: the three biggest mistakes that testators, that's the person who makes a will, that the testators make that sends their adult children straight to court to fight it out, to duke it out, which is probably every parent's nightmare. They don't want their kids to fight after they're gone, but they make these three mistakes that lead them to do it. And Charles, I'm asking you because you've been in a litigator for over 40 years. You're an estate mediator now. You focus on sibling estate fights. So who better to tell us what these three big mistakes are? What's the first one?
Well, there were so many choices, but I tried to narrow it down to three for this talk. So the first one would be any situation where the testator is doing a complete change to their will, a complete 180, where one of their kids has been in the will for many, many years, or even several versions of earlier wills, and all of a sudden on their deathbed or in some other situation, they do a 180 and they take that child out of the will. And it could be an emotional response to an argument they had, or it could be they could be subjected to undue influence by another child, but that's guaranteed to cause the red flags to go up when you see this 180 in the estate plan.
All right. And does this happen often?
It happens. It happens quite often where uh, uh, people change their wills dramatically, and then the issue becomes, were they unduly influenced that even have the capacity to make that will? Because what were they thinking? And the problem can is sometimes not really dealt with properly by the drafting lawyer, who because the drafting lawyer has to take the time to ask the questions and ask about previous wills and saying, wait a minute, this is a real wholesale change to your earlier wills. Why are you doing this? And the lawyer should be taking, very detailed notes, and if need be, perhaps having the elderly client send for a capacity assessment if there are any concerns about testamentary capacity. So,
So, and testamentary capacity would be what, the mental state or?
would be the capacity to make a will. So, first of all, do they know what they're doing in terms of they're signing a will? Do they know what their assets are? Do they know who their potential claimants to their estate are? In other words, they know their family members, and do they realize that there could be a claim if they cut out a family member? And have they thought about it, and why are they doing it? Are they suffering from any illness, like dementia, or do they have depression? Do they have an alcohol problem, a drug problem? In other words, the lawyer's got to take the time um, to understand and to make sure that the client is be satisfied that the client is capable of making that will. Otherwise, that lawyer is going to be dragged into court too as a witness, or possibly worse, as a party being sued for making the will. So it's a difficult situation, but the best thing a lawyer can do is to drill down, make the notes, and get assessments if they feel it's necessary.
All right, there you have it. That was the first of the three mistakes that testators make that send their adult children to court, is making a 180 change, an emotional change, a deathbed change, cutting somebody out of the will. So, Charles, what would you say is the second biggest mistake that testators might make that could send their kids to court to fight it out?
um, Treating children unequally in the will. So there's no question, if you treat them unequally, the child that's not getting as large a share is going to feel slighted, and may very well decide to sue after the death of the parent to challenge that will. Uh, or So that's always a problem, and it's a problem even if the parent or the testator puts a detailed explanation in the will as to why they're treating children unequally, or if they tell the lawyer why they're doing that, or even if they leave a letter saying why they're doing that. Because no matter how you slice it, if the kids aren't being treated equally, they're going to be disappointed, and they're going to fight. And you can tell them, well, look, your parent had this reason, your father had this reason, your mother wrote this note. I've had cases like that, and if they're upset enough about being treated unequally, because to them it's not only money, it's a sign that they take it their parent didn't love them as much as the other kids, and it goes right back to their childhood. So it gets very emotional. So no matter what you do to try to prevent a dispute in this situation, there can very likely be a dispute.
What are some of the reasons that a parent might do that? Treat
Well,
kids, is it just they like one kid better than another kid?
well, yeah, mom always liked you best, as Tommy Smothers used to say to his brother. Um, well, there could be very good reasons. One child might have been more involved in the parent's life. They might have been taking over the lion's share of caretaking responsibilities for their parent. They may even made sacrifices by giving up their job to move in with the parent to take care of the parent. Um, uh,
Okay.
a child may have special needs. Uh, a parent might feel that one child doesn't need the money because they're a zillionaire and the other child can't make a living. But once again, that's going to, fuel resentment because the child who's more successful is going to say, "Why am I being penalized for being successful?" So
Okay,
it's a
that's a
very
good point.
difficult situation.
That's a good point. So again, our three biggest mistakes. Number one was this emotional turnaround, the 180 deathbed change. Two was treating kids unequally. And Charles, what is the third big mistake that testators sometimes make that send their adult children straight to court to fight it out?
Well, believe it or not, treating the children equally can lead
What?
to
I mean, they're
problems.
supposed to treat them equally, right?
Well, you would think equal is fair, but equal being fair is not necessarily equitable. So it depends on the situation. But there's lots of cases, and I've had lots of situations where one child was expecting a larger share because I said they made sacrifices, let's say caregiving rather for the parent, and the parents promised them the house or promised them more money for making sacrifices, and the parent doesn't put that in the will or doesn't deliver, and that's a problem. Or a child's working the family farm for next to nothing all their life, and the parent says one day, this farm will be yours, and then they leave the farm equally to all the children. And the kid that's worked the farm for all those years said, "But you promised." So they'll sue because they'll say the parent promised you something they didn't deliver. So we've had lots of cases like that where although the will says everyone's treated equally, that wasn't the plan. There wasn't supposed to be equal treatment, and the disappointed sibling goes to court.
That could almost be a fourth one, actually, because you said, treating them equally could be based on their expectation, but the fourth category could maybe that they made outside promises that they didn't fulfill.
Definitely, like I said, it was hard to distill it down to three.
Yeah,
There are
yeah,
many
yeah.
mistakes that people make, but one of the main mistakes that we didn't talk about is people making their own wills without proper
Ah,
legal advice and financial advice, and we get a lot of business out of that situation.
all right. Well, we promised you three folks, but you got five. The five biggest mistakes that testators make that send their adult children straight to court. Our guest today has been Charles B. Ticker. Charles, thank you very much.
My pleasure.